Well, part of the South African Divorce Act has been ruled unconstitutional by the Pretoria High Court. It was found to be discriminatory towards women. Specific sections, of the Act have now been referred to the Constitutional Court for review to see if they do indeed violate the country's constitution. This is especially for women who were married out of community of property without accrual post-1984. Divorce lawyer, Advocate Vanessa Mokwena, joins us now to further elaborate. Advocate Mokwena, thank you so much for your time and thank you for joining us. I think let's start with a look at South Africa's matrimonial system. It does seem that over the last 25 years or so, a lot of change has been made to it, particularly as it relates to women. But talk to us about the different marriage regimes that are currently available in South Africa.
Okay, thank you for inviting me. In South Africa, you can be married in one of three ways. It is in community of property, out of community of property with accrual, and out of community of property without accrual. So when you're married in community of property, it means that, in essence, the law sees yourself and your spouse as one person. You share in the assets and the liabilities of the marriage. Where you're married out of community of property, it simply means that what you go into the marriage with is kept intact at dissolution. But if you're married out of community of property with accrual, then the spouse who has less accrual can claim some of the accrual of the spouse with a larger accrual in their estate. And if you're married out of community of property without accrual, it simply means nothing is shared. You leave with what you came in with.
Right. So the High Court in Pretoria found problematic that Section 7.3a found that it's in fact unconstitutional, and that relates, as you've just mentioned, to being married out of community of property without accrual sharing. I mean, talk us through a lot of the instances that women have found themselves in situations where they were married out of community of property without accrual and were pretty much left destitute coming out of their marriages.
Yes, like for instance, the facts of the case that we are discussing, where a economically disadvantaged woman gets married to a more wealthier man or spouse, and she becomes the person who stays at home to look after the house and home, to raise the children, while the spouse is able to increase his wealth or increase his estate. And then should that woman who finds herself in that position where she's on the lower end in terms of the economy of the marriage, should the marriage end, the only thing that she can claim for is maintenance, but she has no claim to this massive estate that her husband has managed to amass. So the problem that the court finds is that those economically disadvantaged women, you find that they have contributed to their spouse being able to amass the wealth that they have amassed, but at the end of the marriage, they are not able to claim anything.
It does seem, though, when looking at this particular case, that the issue is that there appears to be a lack of proviso wherein a court may actually exercise its own discretion because there are other options available when it comes to antenuptial contracts. You can get married out of community of property with accrual. It seems the issue here is specifically in areas where people have gotten married out of community property without accrual, and further to that, the court can't actually exercise its discretion even in those matters to assist disadvantaged or previously disadvantaged women who have entered into marriages and have assisted their spouses in amassing wealth but no longer have any claim to a share of those assets.
Yes, so the proviso is there. The problem is that the proviso says that you need to have gotten married before the Matrimonial Property Act was enacted. So the proviso, in fact, left out people who got married after the Marital Regime Act was enacted. So like the lady in question, she got married after the Matrimonial Property Act was enacted, and therefore the proviso did not cover her situation. So that is exactly what the court is saying is unconstitutional, that there seems to be a line in the sand based merely on the date that you got married. So that is essentially what the court has a problem with, that people who get married after the Marital Property Regime Act was enacted, the proviso does not assist them. While people who got married before, the proviso does assist them. They are able to make an application to the court to be assisted in, to be compensated for their contribution to their spouse's accrual, or rather to the contribution of their spouse's increase in wealth.
You know, I mentioned earlier that the sort of marriage regimes that we have in this country have undergone a bit of change over time, given the general inequality that is unfairly skewed against women. And I would say that at the heart of this matter is the issue of gender equality in South Africa. You are a divorce lawyer. You have a lot of experience in this area. I wonder, does what this case is seeking or looking to change make improvements upon, I would say, the socioeconomic standing of women in these matters?
Yes, I would believe so. Remember that most of these acts, the Marital Property Regime Act, the Divorce Act, they all came into, they were all enacted before our Constitution was enacted. So when our Constitution came to play, it provided all these rights that now the courts are seeking to help these legislation catch up to our Constitution. And that is why the courts are able to make such recommendations to the Constitutional Court, so that rights that were previously not recognized are now able to be recognized. So in this case, we are going to see things as the right to equality, the right to dignity, where you are economically disadvantaged. Cases such as this will elevate you to almost the same status as someone who may be more economically advantaged than you are. And that is what the law is. It's a life, because life keeps developing, so the law needs to catch up to the way our lives are developing.
All right. Advocate Mokwena, thank you so much. We are going to have to leave it there. That's a divorce lawyer, Vanessa Mokwena, helping us to make sense of that ruling made by the Pretoria High Court declaring parts of the South African Divorce Act unconstitutional as it relates to marriages out of community property without accrual sharing.